If you are an adult, you have the right to choose who to live with, who to marry. Your constitutional right only if it was as simple as this. The fact that it isn't is clearly reflected in how the Allahabad High Court has had to overrule and take on a lower court. Allow me to explain, because our lens is tonight on our judiciary, our ultimate citadels of justice, and what appears to be their inconsistencies to ordinary people like us. But is it? We of course have legal experts to take us through all of this to have the right perspective. Look at this. Allahabad High Court today had to assert a constitutional right. It said, no one can prevent an adult from going wherever they choose, staying with a person of their choice, or solemnizing a marriage according to their will or wish, as this is a right derived from Article 21 of the Constitution. Why is this important? One, of course, the context of the case, which I will explain, and second, a series of orders that even may appear contradictory. Let's start with the latest. The woman and the man in this case were husband and wife with a certificate of marriage by a Waqf board. So they even had a certificate of marriage. But a magistrate's court decided to send the woman, the wife in this case, back to her uncle's place. And by the way, this woman had told in a confidential statement that there is threat to the life, there's threat to be living in her parents' or her uncle's place. The 21-year-old woman was ironically handed over to the uncle after he lodged an FIR against her husband for allegedly kidnapping the woman, and the police had arrested the husband. The court seemed to have turned a blind eye to the threat to the couple's life and their safety. Forget about marriage. This was eventually undone by the Allahabad High Court. And remember, the Madhya Pradesh court last month dismissed an interfaith couple's plea seeking police protection and registration of their marriage, observing that the union of a Muslim man with a fire worshipper woman is not a valid wedding as per Muslim law. As per Muhammadan law, the marriage of a Muslim boy with a girl who is an idolatress of a fire worshipper is not a valid marriage. Even if the marriage is registered under Special Marriage Act, the marriage would be no more a valid marriage and it would be an irregular marriage. Legal experts we spoke to even on this show beyond the headlines said it was a completely wrong interpretation that even overlooked the plea for protection by the couple. Why is this plea of protection in such cases so huge? It is because dishonor killing is a reality in India even today. And the numbers are worrying. It's up on your screens. Look at them. We're talking about 2024 India. Despite the fact that many of these instances of dishonor killings are actually categorized as murder in NCRB data, according to experts. Moving over to court's orders, right around that time when Allahabad had overturned that other order, right around the time of the Madhya Pradesh court's order, there was another judgment by the Allahabad High Court that while granting protection to an interfaith live-in couple facing threats, the court observed that the law permits interfaith couples to marry under the Special Marriages Act without conversion. There seems to be absolute inconsistency in how these laws were interpreted. Of course, one argument could be that this is why you have systems of lower and higher courts and review petitions and appeals. In fact, look at this. In January 2024, pleas by 8 interfaith couples were rejected by the Allahabad High Court. And it's just coincidental that so many instances from Allahabad High Court are what we are discussing today. But nonetheless, it's interesting that this is coming up in this sense. Now, what was this case? These 8 interfaith couples, they pleaded for protection for their lives. 5 Muslim men who married Hindu women and 3 Hindu men who married Muslim women. The court went on to identify in this way, and that's why we are doing it. Now, why was this plea rejected? Because the court said marriage was not compliant to Uttar Pradesh's anti-conversion laws. Of course, there's so much in legal parlance that may not make sense to people, ordinary people like us. There may be many questions, and that's why the best to get a sense from are legal experts. And I'm being joined at this point by Sanjay Hegde, who's a senior advocate, Pawan Reli, who's an advocate on record, I'm being joined by Brinda Adige, who's an activist, and Nirmal Kaur, who's a former IPS officer. Thank you very much, all of you, for joining us. Let me just go across to you at this point, Nirmal Kaur. Ms. Nirmal Kaur, do you really see a huge concern in what's unfolding? Because one, of course, I will not get you into the legalities of this, but at least prima facie what it seems is there are couples who are right there before the court pleading for protection, saying that we are not safe, we are not able to be in marriages. There was a case where they actually wanted protection to be able to go to the registrar's place to be able to register their marriage. So many such instances, but the court is going into the legality of the cases, which is fair and open to interpretation. We have legal experts for that, but overlooking possibly the entire appeal for protection.
See, the appeal that you get, a 20-year-old girl or 21-year-old girl, different social systems or religions have different views of marriage. If you see the Abrahamic law, marriage is a contract. If you see the Sanatan, the Hindu law, as per that, their marriage is a sacrament. So different people have different views of marriage, different social groups, different ethnic groups, different religious groups. So in case of these interfaith marriages, or it's important that the basics are laid down. And the Khap Panchayats, of course, have been very active on this front, which is not good really. Sometimes they've come out heavily against same Gotra marriages or Sapinda marriages, things like that. The thing is, the legality which is open to interpretation, it is so wide. There's no linearity to it. There is no. I mean, it's not a quadratic thing at all. You cannot figure out.
That's fair. That's a fair point you're making. You're making a fair point, Nirmal Kaur, but I'm not even getting into the legality yet. I'm asking you about a very simple thing. Are courts looking at just the laws and busy interpreting it while losing what may be really the spirit behind it? There's a text and there's a spirit. There's a text and there's an underlying message. Are the courts totally seeming to overlook all of this?
I think the spirit is the most important behind there. Marriage as an institution, what are the purposes? What does it, what are the functions of marriage? What does it seek to establish? So long as that is kept in view, two individuals living together of their free will, even live-ins are now acceptable, very widely acceptable. Courts have laid down laws protecting children out of such marriages also, and property laws and things like that. There are many facts, many facets, many things which a marriage establishes. So long as those are established in these interfaith marriages, I think courts somehow, there's a certain, when a layman, when a general person tries to interpret it, I think for that matter, anyone, there's a certain, you can say, certain freedom to it, which kind of borders on the arbitrariness. That is my view.
Okay, all right. I'm also being joined at this point by Sanjay Hegde. Sanjay Hegde, if I can come across to you at this point. Now, when I was introducing this entire case, we of course have what's happened at Allahabad Court today. But we also have what happened earlier in an instance where an interfaith couple were denied protection. And they were said, even if you go ahead and marry in a particular, under the Mohammedan law, the marriage is not going to stand its course. It's not going to stand its legality. Then you have another instance now. It was in January 2024 where you had 8 petitioners, interfaith couples, petition the court and say, we want protection. They were married. But the court went on to say that your marriage is against the Uttar Pradesh anti-conversion law. And then they denied the right to protection. Now, there are so many questions, but my first question, there seems to be inconsistencies in how these laws are interpreted. But firstly, with what came today, that Article 21, the right to choose, the right to marry, have been portrayed as sacrosanct. That may be so common sense for people like us, but it really isn't working out panning out like that on the ground?
Well, I do agree that courts have been inconsistent, but those have been the High Court. The Supreme Court has been particularly consistent. The Supreme Court has said that if two people want to get married, they can get married, as long as they don't have another spouse and things like that. And the Supreme Court has always told the High Courts that people who want protection, it's your job to give them protection. Right now, the High Courts seem to be refusing to listen to the Supreme Court, and it probably we will come to a stage where the Supreme Court will have to pull up a few High Courts in their judgments. Both the Supreme Court and the High Court are both constitutional courts. The Supreme Court has an appellate right over the High Courts, and it may, through some judgments, have to tell the High Courts in no uncertain terms that irrespective of who the couple is, are they interfaith, are they only living together, if they need protection from anyone, then it is the job of the courts to order the state to grant them that protection. The court cannot go around looking into the illegalities or the social mores which govern marriages. Even if two people are living together and they want protection, and even if they happen to be an interfaith couple, court, according to the law as laid down by the Supreme Court, they have to be granted protection. They are citizens of India. Marrying or living with a partner of one's choice is part of the right of life, as has already been held in Hadia's case and a whole host of other cases. And no matter what, the parents may have their own views, but they do not count. It is the protection that the people in the marriage or the relationship seek, which the courts are duty-bound to grant. I do agree that there has been inconsistency. This inconsistency will have to be properly addressed.
No, Sanjay Hegde, if I may, now let's just break down these cases. In the latest case, and it's so ironical that the woman who was a wife in this particular case is sent back to her uncle, who the woman had actually claimed that there was a threat to life in her uncle or her parents' place. So one, she's a wife, she's been taken away from her husband has been arrested, and this woman is then sent to her uncle's place where she had already told the police and in the 364 statement that, listen, there's a threat to my life. And this is not just one case. I was going through a series of other cases, and I'm only looking at cases since January. Repeatedly, there seems to be an emphasis on what seems to be the law, the process of law, as it is often said. But are we then missing the spirit?
It is not the law. The law as declared by the Supreme Court is exactly what I told you, that if two people want to live together, they must be allowed to, within a marriage or without a marriage. And if there is a threat to their life from anyone, the state is duty bound to protect them, and the courts are duty bound to order the state to protect them.
Irrespective of whether the court says the marriage is valid or not valid, for whatever reasons they decide.
Yes, absolutely.
Isn't it?
Absolutely. Absolutely. Unfortunately, the high courts tend to get into patriarchy and a whole host of other circumstances, looking at the family wailing and shouting and whatnot. And they try to resolve things in a manner which is consistent with societal patriarchal norms. That is not the court's job. The court's job is to interpret the Constitution, and if the Constitution says that two adults want to live together and they have a right to live together, then the court should not look any further.
Okay. Pawan Really also joins us right now. Mr. Pawan Really, what would you say to just the inconsistencies in the court orders? Now, why is this happening? Because a simple person, a lay person, you may say, yes, there's a Supreme Court that will overrule everything, that will bring in everything in perspective, that will set things right. There are petitions, revision petitions, whatsoever, that entire system is in place. But for an ordinary citizen to knock at the door of any court, lower court, magistrates court, whatsoever, is a Herculean task. That mental, financial block is a huge block to overcome, and particularly in cases like this, it's even more difficult to be able to knock at the door of the court. Often it is after the police and so many other systems in the society have completely failed, and then you have something like this, as inconsistent as it can get.
Yes. Now, in order to answer that, I would like to tell you that I'm also surprised to see these kinds of orders. And this is not a law which has just been laid down by the Supreme Court, before 6 months or 1 year. The first judgment which was focused by the Supreme Court and delivered beautifully was Lata Singh versus State of UP, which came in 2006. And after that, Justice Deepak Mishra has passed another judgment, which is famously known as Hadia case, which came in 2018, which is famously known as this Shafi Jahan versus Ashokan. And court very clearly held that this freedom of marriage is a part and parcel of Article 19 and 21 of the Constitution. Now, there can be various reasons, as the question you have posed. There can be various reasons that why there is a different interpretation. First, I would like to tell you that in relation to when these trial court interprets the judgment and orders, first thing, they cannot interpret the judgment because they do not have any authority and power to interpret that. What they can do, they can just apply the law passed by the Supreme Court as it is. And it is because of Article 141 of the Constitution, which says that law declared by the Supreme Court shall be binding in all courts. But despite that, this is not a matter of inconsistency. This is a matter of non-compliance, absolutely. And I believe there can be multiple reasons for that. And I find first reason, which is practically, I would like to tell you the first reason is the heavy workload and the case backlog. When you go to district court and the trial court, you will be surprised to know that 60
sorry,
to 80
I really can't buy that
in.
I'm really sorry, sir. No, I really do not think that's a reason that we can buy
I'm not saying, yes.
I would be rather disappointed
I'm not
if you
justifying
say
that, but
as your
these are the
first
practical
reason.
realities I'm telling you.
I mean, if it comes down somewhere in the lower list of reasons, I get it, but that really can't be the first reason for an absolutely wrong interpretation or inconsistent interpretation of the law, sir. I'm talking as a common person.
But I can understand, I can certainly... I'm completely with you on this, that there is certainly a non-compliance, but as you sought for the reasons, the practical reasons, when you go deep-rooted reasons, the first reason is this: there's so much backlog and there's a lack of training. There is so many social factors which tend sometimes their mind. There are, I will say, sometimes there's a pre-notional bias also. I will tell you, the judge who's deciding the matter in Delhi, his mindset will completely be different from a judge who's disposing of the matter or deciding the matter in a very small district in Uttar Pradesh and Bihar, I'm completely with you, which is absolutely wrong. But these are the practical realities.
I know you're raising an important point of culture and traditions and mindsets, but then that's never going to have a limit at all, Okay, allow me to just go across to others as well. Brinda Adige, to what we saw right now, and it's interesting that the court said that. It's very important that the court said that. In the court, the Allahabad court not only pulled up the magistrate on that, but also the police officials on that they use the word honor killing, but we would rather use the word dishonor killing, that it is very much a reality in India. But as we discussed, each one of us discussed, and we have the numbers on our screens, some may say, but these are not big. Look at these numbers. We're talking about 2024, and many of these don't even get registered as, they are not even categorized as dishonor killing, for that matter. There's no category like that. It's a murder category.
Yes, Sneha, you're absolutely right. I have two things to point out over here. One is that almost all our structures are patriarchal. Functionaries sitting there are even more patriarchal, and so they continuously impose upon women their understanding, their religion, their stereotype. Second part of it, like you said, the police have no other option to register it other than murder, because that is what the law is. That is what CRPC sections are. Where in the CRPC does any section claim there is something called dishonor killing? No, it does not have. So the police can only do that. The numbers that we see on your screen are very small numbers, and they are not the truth, because often the police register it as a UDR, and that is an unnatural death. and the parents and the families are not very keen to register a case and make a statement over there that this was done in this manner because they got married, because of interfaith, because of interreligion. So those statements don't come out because there is a whole social sanction against interreligious marriages or intercaste marriages. So the families do not want to bear the brunt of the society or the community afterwards. So usually they keep quiet. Now, that said, what stops any magistrate or judge to interpret, look at the law in its most dynamic fashion, because that person has been given the power. It is not that somebody is asking him or her to do any charity. They have the power to look at the facts of the case, whatever has been presented vis-a-vis as statements by the people coming before the court, and pass a judgment accordingly. Now, if this particular judge or some judges do not pass such laws, where in India has any of these judges been pulled up? Nowhere. Have they been reprimanded? No. Mr. Pawan spoke about
That's an
training.
important
Training
point.
is very
Yeah.
important. One moment. Training is very important. But you look at the training that is also constantly being given by only other judges or probably some lawyers and probably few people from the civil society organizations. We do not have people coming there talking from either a feminist point of view or, in fact, a rights-based point of view. Now, both of that is missing. The Constitution is my fundamental supreme book. I cannot go out of it. I cannot do anything beyond it. Now, how does a judge decide that, this is a protection that I will not extend to you? Who is this judge? After all, a government servant. So this government servant decides that your life is not so important, need not be protected, and the police need not do the job. His job is to ensure, because courts are our final and last recourse. Everything else would have happened. We would have gone to panchayats, the elders, we would have gone to the police station, probably even the lower courts. Then you come to the highest court.
Okay.
We're talking
Okay.
of cumbersome, tedious procedures.
Okay.
We're talking of money involved. We are talking of the immense social and mental trauma that these couples go through. And that is unacceptable.
Okay.
There must be judicial reform, and it must happen now.
Okay. Okay, Sanjay Hegde, to what Mr. Rayleigh as well as Brinda Adige have said right now, there's no doubt training is important. To whatever I may have, I may have been taken aback with what Mr. Pawan Rayleigh said. Yes, but even the burden of work, if somebody has to say that, okay, let them say it. I mean, I may not really take that in. But the point remains, is there also just the fact that there seems to be no punitive action? I mean, have you heard of a judge being called and said, review this? Has a judge been questioned on why this came up? Is there every system should have an internal system of correction. Every system needs, everywhere there's something internal that happens. Nothing happens in the judiciary. There's an appeal that goes up, another court takes it up, there's another order that comes in. But then what happens to the inconsistent interpretation of an order that would have happened earlier? There's no accountability, is there?
The way the system is, there can't be an accountability, because ultimately it's also a question of the judges having a free hand in deciding matters. They are supposed to follow the law as laid down by the Supreme Court, and if they do not follow it, the Supreme Court is there to correct them or correct their judgments. The thing is that trial court judges could possibly be reprimanded or could possibly be told, but as far as the High Court judges are concerned, they have constitutional protection. They cannot be removed except through a process of impeachment. And it's also the judgment of the Supreme Court that courts do not use harsh language. So they may say, with great respect to the High Court, we believe that the High Court was entirely mistaken in ignoring our earlier judgments, etc., etc. That is a reprimand. But no doubt, I have no doubt that, if there are some judges whose judgments particularly reek of this kind of patriarchy. It would do well if senior judges of the same court, maybe even the Chief Justice of that High Court, but to kindly take them aside and say, brother, these judgments of yours are causing problems. Maybe it is better that such matters you do not listen to. There are ways within the system.
With your years of experience, have you ever seen this happen?
Well, these are not things that are put out in the open, but
certainly. I mean, but you are an insider, sir. I'm sure if this happens, you would have known it.
Let me put it.
I may not know it. You would know it.
Sometimes messages do go, sometimes messages don't go. So I will not categorically say this way, that way. But there is nothing called disciplinary act.
Okay.
That's the point I wish to make. But forget all that. While I was listening to my friend Pawan, it did strike me that there is one more factor that we have not talked about. Most judges are in their 50s and 60s. They tend to identify more with the parents than with the younger people. That is a human problem. And I do think that in such cases, judges should be able to leave aside their personal predilections and say, look, the Constitution has told me to do this, that is to protect every citizen, and I will protect. The rest of your problems, please solve it at home or wherever else.
Okay. Nirmal Kaur, if I can come to you next, you heard of this speak. Now, when we're talking about even the police force for that matter, in the latest case as well, you had the police also being pulled up. That how could the daughter be sent to the uncle's place? And there are previous cases as well. There are earlier cases as well. Now, my question is it so legally bound that if the petitioners move the court and the court, say for whatever reason, have been blind to what the plea for protection essentially is and have got into whatever the constitutionality, validity, invalidity of marriages, that, as all of us have discussed, is certainly not required, is unmerited, is inconsistent. But as police forces, can't they set this right? If there are two people who want a protection, and if it has come out in the public, if it is in the court, and if the court has set it aside, can't there be an intervention from the police that, listen, these are two people who have married for whatever reason and they face a threat? It's absolutely off the law?
Police, so court orders for police are sacrosanct. Whatever the court has laid down, court alone can change. Maybe a higher court can change. Maybe when they go in appeal, it can change. Maybe the court itself can review its own decision. But once the court has passed an order, that is sacrosanct for police. Police is not going to change it only because police find it
what is the process?
More kind of
if
situationally
I want
correct.
protection in my marriage, and what are the options I have? Can I can go to the court, but can I go to the police directly?
If you have not gone to the court, yes, police on its own can provide whatever the basic protection is. But once you've gone to the court and there is a court order, police is bound by the court order. They, at that place, they cannot, suo moto on their own or even on your application, go against the court order. Even if that may seem prima facie more
But then why did the Allahabad court pull up the police then? The police could have said, we have done what the court told us to do. But clearly the police team was also pulled up in this particular case.
No,
then how could you allow for the girl who has said that there is a threat to my life in her uncle's place be sent back to the uncle? I'm just trying to understand.
The court has said the police is perfectly right to follow the court order. The court order, to borrow Allahabad, I mean, the courts want their order. That's what courts are. They are higher in that pecking order. Once there is a judicial order, the police is bound by court orders. Whatever the court decides, whatever the prosecution, defense, or whatever we do, it is all reviewed or it is all presented before the courts who pass orders, and then the police acts accordingly as the court's order. So police, once the court has ordered, police has no discretion.
Pawan, really, if you have couples who are listening, right. Okay. So Pawan, really, if you have couples who are listening to you today, if you have young couples who are wanting to get married in this particular direction, who may have got married if they are looking for protection. And they see just how inconsistent the courts have been. They obviously can't jump and go to the Supreme Court directly. And it would take a lot of courage for them to go to any court. What are the options before them?
Special Marriages Act.
Yes, so I believe first they should write if they are also afraid of sometime, I have found that they are also afraid of going to the police station. So what they can do, they can write one complaint and send it through the speed post to the police and also to the superintendent of police. They can also send an email that they have the live threat. They can also dial 100, and after that they can file a writ petition before the Honorable High Court under Article 226 seeking the protection, relying on those emails, relying on those complaints which they are saying, stating that the police is not taking action or they have also threat from the police, and then they can file that and then they can take the protection from the court. And I believe that the court will certainly look into these aspects because court is the ultimate guardian of the constitution and the protector of the fundamental right. So I think this is the way they can take. If they are afraid of the police, they can certainly drop the email, they can write letters to the superintendent of police specifically, because the situation before in the police stations is different. The people who are sitting in the higher authorities, sometimes they can understand these things. They can understand the real problems, because those police stations which are there, they are surrounded by, they have their own societal factors. They have, yes.
Okay, Sanjay Hegde, I know, I think I saw you raise your hands, but allow me to just go quickly to Brinda Adige. Brinda Adige, could you just bring to us the reality? I'll give you 2 minutes, a minute and a half maybe. Could you just explain to our viewers just how intimidating, how threatening it can be for a couple, even in today's India, to be in the society and marry against what the familial norms would be? And I'm asking you this because I was also a reporter on the ground covering the Hadia case. And I saw how vicious it got on the ground, even from her family as well.
Yes, Sneha, like I pointed out earlier, social sanctions do not allow a couple to come together. And not only are they scared of their own families, but the families and the couple are, sometimes one family agrees, the other may not, because the entire community will come and the police do not intervene. Now, let's assume that the community has not done anything. They're going to go to the police station and register or file a case. Now, these cases don't get registered. We spoke about the police extending support, but even at the police station, we have personal experiences. Even at the police station, there's a lot of so-called counseling, literally intimidation and threat being done by them saying, don't get into this kind of a relationship. See what will happen. If you are killed, what can we do? So the danger is in every step. And the danger is not only for the woman, but also for the man. So both of them are not safe. Now we are asking maybe a poor couple, maybe a middle class couple to go to court, file a writ petition. We are talking of hours, 24 hours or less. Where would they go? So you find that they will elope. Not that they are going to be safe, because in this age and time, the parents go and give a complaint of kidnap. So their cell phones are tracked and they are brought back or finished off there itself. We need to ask ourselves, what is my system doing?
No, in this particular case, that was exactly what happened. And the girl was handed over to the uncle and the husband was arrested.
Yes, exactly. So the girl is now is in a dangerous situation. Why should an adult be put into the hands of another person called an uncle or whoever it might be? Why would you not respect a woman's choice?
Okay.
This is my country which says 18 years and above, you're an adult, you can make a choice. You can go live with anybody and marry anybody. Why would the courts, the justice system, not respect this woman? Stereotypical, gender biased.
Okay, I'm totally out of time, but allow me to give a minute to Sanjay Hegde. Right, Sanjay Hegde, if I can just come a minute to you. There are so many things that each of our panelists brought about. So one, you have at times cases such as this being turned into, for whatever reasons, as cases of love jihad on the ground. Then you have other cases of family ki maryada, of respect of the family, of whatever. These are the narratives that are churned out on the ground. And then you have a court where things are falling apart. To anybody who is watching us, What would you want to say for the last 40 seconds? I'm leaving the show as your last word.
Well, what I would like to advise the young people is to solemnize your marriage first. Solemnize your marriage either through the registration process or even an Arya Samaj temple or something. Get your marriage out of the way. Set the law in motion. Ask for police protection. And yes, Pawan is right. Go up the police ladder. Go to the ACPD commissioner's level, and then thereafter only move the courts if necessary. And look, there ultimately the policeman decides what is more trouble to him, whether to provide protection is less trouble, or whether to listen to the family is less trouble. So we have to get to a situation where it becomes less trouble for the policeman to provide protection and more trouble for him to listen to the family.
Right. Okay, all right. Thank you very much, all four of you, for joining us. Sanjay Hegde, Pawan Reli, Brinda Adige, as well as Nirmal Kaur. Thank you very much. All of your perspectives are extremely important. We'll continue to focus on what comes out of the court, as I have done before as well. These are important conversations for the India that we are in today. Thank you very much.